Meeting of Budget and Finance to order. Today is Wednesday, March the 6th, and I do detect a quorum with Councilmembers Porterfield, Allen, Cortez, Councilmember Druffel, Councilmembers Evan Siegel, Councilmember Gregg, Councilmember Gamble, Councilmember Huffman's absent today, Councilmember Johnston, I believe, is absent. Councilmember Kimbrough is present. Councilmember Spain is present. I believe Councilmember Sewell is en route. Vice Chair Toombs is present, and Councilmember Webb is present. For committee members, if you don't mind, please remember to put up your yellow tag to show that you are a committee member. Thank you for those of you who have already done that. We do have a few announcements that will be reserved for the end of the committee meeting today. So if you can hang around for about 3 minutes after our committee meeting, we will have some announcements. We did not have anyone to sign up for public comment, so we're going to go ahead and jump right into the agenda. The items that we have on the consent agenda for recommendation for the consent agenda are RS 2024-266, RS 2024-267, RS 2024-269, RS 2024-271, RS 2024-272, RS 2024-273, RS 2024-274, RS 2024-275, RS 2024-276, RS 2024-277, RS 2024-278, RS 2024-279, RS 2024-280, RS 2024-281, RS 2024-282, RS 2024-283, RS 2024-285, BL 2024-232, BL 2024-233, and BL 2024-237. Is there anything that anyone would like to pull off of the consent agenda? Councilmember Allen, you are recognized.
Thank you, Madam Chair. I just have a question about RS 2024-266.
Okay, 266, we will bump that off. All right, is there anything else? Seeing none, I will go ahead and read through the captions on the consent agenda. RS 2024-267, Porterfield, Evans, and Bradford accepts a comprehensive opioid, stimulant, and substance abuse site-based program grant from the U.S. Department of Justice, acting by and through the Office of Justice Programs to the Davidson County Sheriff's Office to serve women with histories of substance abuse disorder who are unhoused in DCSO facilities during their period of incarceration and upon re-entry into the community. RS 2024-269, Sepulveda, Gamble, Johnson, and others amends Resolution RS 2022-1906 to update the Metro Action Commission's scope of repairs and safety improvements to Metro-owned child care centers. RS 2024-271, Sepulveda, Gamble, Johnson, and others appropriates $1,630,679 in the American Rescue Plan Act funds from account number 30216 to extend the provision of critical immigrant legal services in Davidson County. RS 2024-272, Gamble, Sepulveda, Johnson, and others appropriate $75,000 in funds from the Nashville Small Business Recovery Fund included in the American Rescue Plan Act funds from fund number 30216 to benefit small minority-owned businesses in Nashville and Davidson County. RS 2024-273, Gamble, Sepulveda, Johnson, and others appropriates $150,000 in funds from the National Small Business Recovery Fund included in the American Rescue Plan Act fund number 30216 to support small business entrepreneurs. RS 2024-274, Soror, Sepulveda, Johnson, and others appropriates $2,395,322 in the American Rescue Plan Act funds from fund number 30216 to provide legal representation to low and moderate income Davidson County renters to defend against landlord eviction. RS 2024-275, Porterfield Gamble approves the First Amendment to a grant contract for constructing affordable housing approved by RS 2022-1857 between the Metropolitan Housing Trust Fund Commission and Crossbridge Incorporated. RS 2024-276, Porterfield, Evans, Bradford, Welsh accepts a grant to the U.S. Department of Health and Human Services to the Metropolitan Board of Health to provide for the prevention, surveillance, diagnosis, and treatment of HIV/AIDS and to administer Minority AIDS Initiative Program, RS 2024-277, Porterfield, Evans, and Bradford, accepts a grant from the Marjorie A. Neal Huff Private Foundation Incorporated to the Metropolitan Board of Health to provide funding for the care and shelter of animals at Metro Animal Care and Control. RS 2024-278, Porterfield, Evans, and Bradford accepts a grant from the Friends of Metro Animal Control and Control to the Metro Animal Care and Control to the Metropolitan Board of Health to provide funding for emergency medical care, the Safety Net Program, and the Foster Program for Shelter Animals. RS 2024-279, Porterfield, Styles, Walsh, and others accepts a grant from the National Public Library Foundation to the National Public Library for the Votes for Women and Archives digitization programs. RS 2024-280, Greg Porterfield, Styles, and others accepts a grant from the Tennessee Department of Intellectual and Developmental Disabilities to the National Public Library for the purchase and installation of a powered adult-sized changing table in the family restroom of the new Donaldson Branch Library. RS 2024-281, Porterfield, Styles, Walsh, and others accepts a National After Zone Alliance grant from the National Public Library Foundation to the National Public Library to fund a program manager position to help supervise NASA capacity building and grant management that focuses on integration of Nashville's vision for holistic youth development. RS 2024-282, Porterfield, Styles, and Welsh accepts a Studio NPL Outreach Coordinator grant from the National Public Library Foundation to the National Public Library to fund the Studio NPL Program Supervisor position. RS 2024-283, Porterfield, Styles, Welsh, and others accept a Public Library Wishing Chair Productions grant from the National Public Library Foundation to the National Public Library to provide puppeteers that help with education outreach by providing puppet shows to daycare centers, elementary schools, and Head Start facilities. RS 2024-285, Porterfield, Evans, Soror approves an application for an emergency management performance grant from the United States Department of Homeland Security by and through the State of Tennessee Emergency Management Agency to the Metro Office of Emergency Management to subsidize the emergency management program for Nashville and Davidson County. BL 2024-232, Gamble, Porterfield, Styles, and Parker approves a greenway conservation easement between the Metropolitan Board of Parks and Recreation and Heritage Creek Homeowners Association Incorporated for greenway improvements. BL 2024-233, Gamble, Porterfield, Styles, and others approves a greenway conservation easement between the Metropolitan Board of Parks and Recreation and Clayton Properties Group Incorporated for greenway improvements. And BL 2024-237, Porterfield, Gamble, and Parker authorizes the Metropolitan government to abandon existing sanitary sewer mains, sanitary sewer manholes, and easements, and to construct new public sanitary sewer mains, sanitary sewer manholes, and to accept easements for property located at 104 Duluth Avenue, and authorizing the Director of Metro Water Services or his designee to execute a mutual release of liability. Is there anything else that anyone would like bumped from the consent agenda? Seeing none, can I get a motion?
Move approved.
Is there a second? It has been moved and properly seconded. Is there any discussion? Seeing none, all in favor say aye.
Aye.
All opposed, nay. Any abstentions? The consent agenda passes. I have 13 in favor, 0 against, and 0 abstaining. Thank you for all of our guests in the back who were here for an item that was on consent. The next item, RS 2024-266, Porterfield, Sepulveda, Welsh, and Gamble, accepts a grant from the State of Tennessee Division of Elections to the Davidson County Election Commission to provide funds to county election commissions for expenditures to upgrade voting systems and improve the administration of elections. Can I get a motion?
Move.
Is there a second? It has been moved and properly seconded. Councilmember Allen, you're recognized.
Thank you, Madam Chair. So the analysis said this was $614,000 for postage and equipment. I just wondered if we could get a little bit more detail on what that equipment was.
Thank you so much. We have someone from the Election Commission, Mr. Roberts, Jeff Roberts from the Election Commission. Thank you so much for joining us, and you are recognized.
Sure. What we're trying to do is plan for the November election, which will be significantly larger than what we just experienced yesterday. So you'll be looking at more ballot marking devices, scanners, printers, that type of situation, so that to the extent possible, we can make it a very pleasant experience for voters on Election Day.
Thank you. It certainly went smoothly with the size crowd we had, so thanks for planning for a big one. Okay.
Are there any other questions? Thank you, Mr. Roberts. Seeing none, all those in favor say aye. Aye. Any opposed, nay. Any abstentions or not voting? Motion carries 13 in favor, 0 against, and 0 not voting. RS 2024-270, Coop and Porterfield, Gamble and Parker approves a memorandum of understanding related to the proposed development of a multi-use performance space for the Tennessee Performance Arts Center on the East Bank property owned by the Metropolitan government. Can I get a motion? Is there a second? It has been moved and properly seconded, and I'm going to call on the sponsor, Councilmember Coopin. You're recognized.
Thank you, Chair. I'd like to move for a deferral to the April 2nd meeting with a brief comment.
Um,
I'd like to ask someone here to do that, please, because I am not on the committee, and thank you for recognizing me.
Councilmember Alley, you're recognized.
Thank you. Move for a 2-meeting deferral.
There has been a motion for a 2-meeting deferral. It has been properly seconded. Any discussion? Councilmember Coopin, I'm going to go back to you for discussion.
So just wanted to let anybody know that's kind of watching at home or here, we are moving this to track with the potential third reading of the East Bank Master Development Agreement. If it passes on April 2nd, there may be a deferral somewhere in that process, and if so, we'll have to defer this again to track with that, that Master Development Agreement, but the goal is to keep them riding together.
Thank you. Is there any additional discussion or questions? Seeing none, all those in favor say aye. Any opposed, nay. Anyone not voting? Oh, Councilmember Evans Siegel, you're abstaining. All right. So motion, is there anyone else that's abstaining or not voting? All right, so motion carries 11 in favor, 0 against, and 1 not voting, because we have 12 in the room right now. The next item on our agenda, RS 2024-284 Porterfield, authorizes the Department of Law to compromise and settle the claims of Tracy Turner against the Metropolitan government in the amount of $105,000, with $97,000 to be paid from the Judgments and Losses Fund and $8,000 in back pay to be paid from the Nashville Fire Department's operating budget. Can I get a motion? Is there a second? It has been moved and properly seconded. Is there any discussion? First, I see Councilmember Cortez, and then we'll go with Councilmember Spain. Councilmember Cortez, you are recognized.
Thank you, Madam Chair. My concern with this is if we settle, and I do want to say I appreciate legal's, thank you for your pragmatic response on this and your approach. My concern is that this leaves department heads really with a lot of uncertainty, knowing what is the line, what is the playing field when we come in contact with these types of issues again. And I'm concerned if we don't see this through, there's going to be a lot of uncertainty around it. And it also opens us up to employees who just want to test the system. And if they're unhappy, they might see this as a way out. So for those reasons, I'm going to vote against it. But I would like the legal department's take on this if they feel there is extra liability. If we do settle now, is there a concern with that going down the line that we leave our department heads without that structure?
Thank you. Director Dees, you are recognized.
Thank you, Madam Chair, and Council Member. That's a really great question. We've taken a deep dive on the social media policy to try to analyze that. Allison Bustle is here. She's in charge of that. She is the head of our litigation team at the Law Department, and she will specifically respond to your question.
So I would say thank you for the question. Fair concern, and those of us who litigate these cases feel the same way about that. It is a subjective test. So this First Amendment speech test is a somewhat subjective test, and so it does make it difficult for department heads to make these calls. I will say our department heads and HR staff are really great about reaching out to us on the front end of these things. And I think we said in our memo, we said we think it was perfectly appropriate to discipline in this situation. So we are in a bit of a unique procedural procedural posture where the judge just disagreed with us. We do believe that the fire department made an appropriate decision to discipline this individual, but we, as the folks defending the lawsuit, wanted to be candid with you all about where this may end up. So you're right, it is this balancing of interests that can be tricky in the moment. But we would certainly encourage, and we do encourage department heads to come to us for those types of questions as they're playing out. And we do answer those types of questions, as they arise. I don't see the particular decision to approve or not approve the settlement as moving the needle on that. The standard is what it is, and you just make those calls. And sometimes we're right about it, and sometimes the judge disagrees. But that's just kind of the nature of this area of law. So I wish it were easier to predict outcomes, but it just is not.
Thank you for that.
Thank you, Councilmember Cortez. Councilmember Spain, you are recognized.
Thank you, Madam Chair. And I think I'm following up on those comments. And I'll preface this by saying I'm not an attorney and don't even play one on TV. But I'm reading from Judge Richardson's ruling from the motion for summary judgment. And in referencing the Pickering test that I think you were just referencing about balancing the employee's interests versus the government's interests, he says that the court would be remiss if it did not comment on the inherently subjective nature of this balancing test and the resulting reality that its outcome in a particular case well may be judge specific. In many cases, different judges reasonably could reach opposite conclusions as to the outcome of that balancing test. And then he goes on to say, so the undersigned will do here what a judge always must do when confronted with any balancing test, call it like he or she sees it. He does so below, confident that his conclusion is a sound one if it is a subjective one. So I guess my question is, that would seem to indicate that even if Judge Richardson rules against us at the trial level, it seems like there might be a reasonable chance that the Sixth Circuit might see this differently. Is that a reasonable assumption?
Director Deets, you're recognized.
Thank you, Madam Chair. I'll say what you quoted at the beginning of Judge Richardson's opinion as one of the few things he said in his opinion we agree with. It is a subjective test. Where we respectfully disagree with this judge is that we believe he got the balancing test wrong. We believe he underweighted the concerns that the Metro government had when these social media posts were presented to the public. It was right after the George Floyd murder. Tensions were running really high. And the department head and Metro Legal believed that his posts were not protected by the First Amendment because as a government employee, if he's a private citizen, he has more leeway in what he can say. But if he works for the government, he needs to understand that the government also has interests in internal discipline, control of the department, but also how the department appears to the people who pay taxes and expect government services. And fire is an essential service. If fire and police aren't essential services, I don't know what is. And so we had a real concern that these posts affected adversely the confidence that the public had in the Nashville Fire Department. We think we were right about that and that the discipline was both appropriate under the circumstances and lawful. But where we are now, we put all of that evidence, including affidavits, statements from citizens who said, will this particular firefighter really fight the fire at my house if he shows up? Desperate, urgent concerns from the public. We believe that merited discipline. And so we defended the case. We put all of that evidence in front of the court. We put all of the law in front of the court. This court did the balancing test, and in my opinion, he vastly underweighted the interests of the Metropolitan government and came out on the side of the individual. I think he was wrong. But here we are with a chance. And this is why we are recommending this settlement to be considered as being in the range of reasonableness if this council wants to settle this case now. Because this is a 1983 action with attorney's fees added on top, and there's no cap. It's not like a Government Tort Liability Act claim where there's a $300,000 cap. There are no cap on these fees. So if we go to the Sixth Circuit Court of Appeal, because we put all of our arguments in front of Judge Richardson, we technically have to go through a final hearing and a trial, but we don't have anything else left to argue. We already know what he's going to say. The facts haven't changed. The law hasn't changed really. And the only chance we have at the trial court is if he changes his mind. And so that puts us at the position where we are likely to have an adverse judgment, including $8,000 in back pay, compensatory damages of an unknown amount. I'm not too worried about that number, but it could be a reasonable number, but then attorney's fees. And so we have an opportunity to settle the case now for $105,000. If we lose and appeal and go to the Sixth Circuit in Cincinnati and lose at that point, we estimate the fees to be very likely in the range of $300,000. So we're looking at a potential adverse judgment between $300,000 and $400,000. Metro Legal decided it was not our job to decide whether to take this settlement or not. You're the gatekeepers of the money at Metro. It's your job to decide if you want to settle this case. We did not believe we could decide that without presenting the option to you. So we are recommending it as being in the range of reasonableness if you want to settle the case at this time. It's actually, based on what's happened at the trial court, a very reasonable number, especially compared to some other settlements. But so this is a unique recommendation from us. Understand that we fully support the fire department's discipline. We believe it was proper. But we are where we are in this case, in this stage of the litigation.
You recognized.
Thank you for that. I think you were right too. And for that reason, I'm going to vote against this settlement, but I appreciate your efforts and thank you for the information.
Councilmember Allen, you're recognized.
Thank you, Madam Chair. Appreciate the detailed explanation, and this just shows I'm not a lawyer. The balancing is a subjective opinion of this particular judge. We will not always be in front of this judge at this level. If a case became before us again, would we have a shot at different judges? I should know how many there are to choose from, but can you just educate us on that, please?
Yes, there are 3 other federal judges, and it's a random draw. So if we are back with a similar case in the United States District Court for the Middle District of Tennessee, which is where we are, Judge Richardson is one of 4 potential draws.
So we can have a totally different outcome with a different judge at that lower level.
As Judge Richardson himself indicated in his opinion, it's a subjective test, and judges very easily can come out on different sides of the balancing test.
So this is not necessarily, it's kind of 25% precedent setting, but not 100%. I mean, if we were afraid that we would see repeats of this.
Well, that's true, but that changes. If we go to the Court of Appeals in Cincinnati and we lose, we will have an opinion that will be binding on all federal courts in the state of Tennessee, because that's where appeals go. Sixth Circuit is the final word, absent the U.S. Supreme Court, for Michigan, Ohio, Kentucky, and Tennessee. So that's one of the issues here is we could go to Cincinnati and win, which we would be thrilled. And we're ready and prepared to do that. We could also go to the Sixth Circuit. And again, it will be highly dependent on who's on that 3-judge panel and which judges we get and what, it could vary. But we could end up with a ruling that would be adverse to our interests as a government to protect our rights in this balancing of our rights versus an employee's rights under the First Amendment.
And that adverse ruling at the higher level would not only be more expensive, but more precedent setting.
It would be binding precedent on all courts in the state of federal courts in the Sixth Circuit. And it would also be precedent that we would have to honor as lawyers in our advice to our clients.
Okay, thank you for that clarification.
Thank you, Councilmember Allen. Councilmember Kimbrough, you're recognized.
Thank you, Chair. I just had a question. The ruling that my colleague read from, what was the issue before the judge that resulted in that ruling? How did we get there?
Director Dietz, you're recognized.
Thank you, Madam Chair, and thank you, council member. You will appreciate this as a trial lawyer. It was a motion for summary judgment. We moved for summary judgment. We put all of our affidavits in, all of our evidence in, and said we should win as a matter of law. The facts were not disputed. So we believed it was ripe for summary judgment, and we moved for summary judgment, and it was denied. So the only thing left is to go to trial in front of this same judge. And that will be, unless he changes his mind, something of a formality. Ms. Bessel here has entertained the notion of maybe fast-tracking this. If he's not going to change his mind, just go ahead and rule, and then we'll go to Cincinnati if we have to, if the settlement is not approved.
Okay, I have another question.
You're recognized.
Okay. So that was the summary judgment, and the summary judgment, is that where you're asking them to make a ruling that would dispose of the case as of now? Is that what it's?
Yes, council member, we asked for a final ruling for the case. Captain Turner, with his attorney, they did not file a cross motion for summary judgment. So the only motion for summary judgment before the court was our motion. And we asked the court to enter a ruling saying there is no reason to go to trial. There are no disputed facts. It's not a case of he said the light was green, she said the light was red. There are no disputed facts here. So we're asking the court to apply the law to the facts, which are essentially stipulated. So we believed we had a really strong motion for summary judgment. If we had won it, the case would have been over at the trial court, and it would have been up to Captain Turner to file an appeal.
Thank you. So are you saying at this point, you have two options? You can appeal that summary judgment ruling to a higher court, or you can go forward with a trial? Is that what you're?
Well, the summary judgment ruling is not an appealable order, because it's not a final order. If Judge Richardson enters a final order with the same rationale that he adopted in his summary judgment ruling, that would be a final order, and we can appeal that to the Sixth Circuit.
Okay. All right. So at this point, if the council decides, no, we will not give this man this $100,000, and let me back up 1 second. He was not terminated, was he?
No, he was demoted.
He was demoted.
And it cost him $8,000 in salary.
Okay. So he kept his job.
He kept a job at the fire department, but he was demoted. He was no longer a captain.
Right. And
For a temporary amount of time. I think it was 6 months.
okay. All right. Okay. So that the ruling did not kill the case, and Metro Legal is in a position where they can still litigate. Is that correct?
Yes, that is right. We still have the options of presenting these arguments to the trial judge. The barrier we see is we put everything on the table. We made the very best case we could. And so instead of affidavits, he will hear live testimony. But if we go through a trial, he will have the same evidence in front of him and the same legal arguments we have already presented.
So he'll be the trier of fact?
It's a bench trial, yes.
So did you have an option? I'm just wondering, for a jury trial?
Not,
Okay.
So the Pickering balancing test that we've been talking about, that is the judge. That's technically a question of law. It feels weird, but it is technically a question of law as to whether the government's interest in protecting the efficiency and operations of the government outweighs the employee's interest in free speech. That's a question of law. If there are facts within that case that are disputed, then a jury has to resolve those factual disputes. For example, if the court would need to know what the extent of the disruption within the agency was, they might present that fact issue to a jury to decide. But if all of the facts, all of what happened are undisputed, then the judge does that balancing test based on those undisputed facts. So that's what happened at summary judgment. We presented all the undisputed facts. And then the judge balanced the interests and concluded that Metro was on the wrong side of the balance. So then the question for trial will be, do we see any disputed facts that a jury would need to resolve? And I think if this case were to go to trial, the opposing counsel and I would probably have a candid conversation about whether we see any disputed facts that a jury would need to decide. I hope that helps.
Right, okay.
You have any other questions, Councilmember Kimbrough?
Not, thank you, not a minute. I just want to make a statement. To the chair. Chair, I think we should, and of course I'll be voting against the settlement, but I think we should support our chief when he works and makes decisions based on the interests of all people, the citizens and the people that he serves. Some of the things he was quoted as saying is that the statements and the post of Chief Swan do not represent the core values of our department. He went on to say that anything that calls into question the ability of our department to serve everyone without prejudice or bias will be addressed, and when needed, discipline will be administered. I think that's very important, and I think at this point, we're setting the tone on what will go on in Metro government regarding racist statements or statements against any protected class or whatever. I think this sets the tone, and I don't think we should be afraid, and it doesn't seem like they are, but I don't think we should be afraid and run and hide every time there's a chance we may lose money. I think there are some things we need to stand for, just as we stood for some things when we had protesters. You know, I don't know how much actual good that will do, you know, the council being united, saying, we don't like what happened, we don't like these people that march the street and stand for hate. I think this is a time that we can actually show it. We can put our money where our mouth is and say, let's do it, you know, let's go. So I hope that we can come together on this as well. I don't know what they'll do, but I will also be voting against it. And I think the chief also said it's important that we have the utmost respect for every person we serve without regard to their sex, race, ethnicity, gender, identity, religious belief, or sexual orientation. I think we need to practice what we preach. Thank you.
Thank you, Councilmember Kimbrough. Councilmember Evan Siegel, and Councilmember Soror, did you have your hand up? You did. I'm so sorry. Councilmember Soror, and then Councilmember Evan Siegel.
Thank you, Chair. And I'm going to be voting against this as well. As I listen to the director speak and talk about our responsibility as a government in terms of the money part of it, I think as a government, we also owe it to our citizens into how they feel about the government. And I think we also talk about president in terms of if this should pass, then it will affect how the courts deal with stuff. But again, if we should back off, then it also leads to another president that said that it's okay to be racist. And I think we don't want to say that. I think that our statement should be that no one should be allowed to disparage our citizens and get away with it, period. That's the statement. And so not everything is about money. I've always said that as a member of the minority community, and when we look at things in terms of dollars, sometimes we lose the value and the core and the essence and the soul of who we are as people. And this is one that speaks to that. This gentleman, we should not send the statement that, oh, maybe the 300,000 is too much for us to pay, so we're going to back off. When actually we may not even pay that. We don't know how that will go. But it is very important for us to send a statement to say that the chief position is one thing, which I like what my friend, my colleague articulated. But for me, it's about the people. As people that read that statement, what did my government do? And so that's what I hope that we as a body will send the statement that we don't agree with this. We're going to take this as far as we need to protect our citizens are viewed. Thank you, Chair.
Thank you, Councilmember Sora. Director Dietz, you recognized?
Yes, thank you again, Madam Chair. As a personal citizen and voter in this county, I agree with everything you just said. This speech was abhorrent. It was over the line. I condemn that speech as a private citizen. Here's the rub. We're the government, and the government cannot regulate the content of speech. We can do a full primer on the First Amendment, but the government cannot regulate speech except to the extent an employee's speech creates internal disruption or discipline problems, or creates a lack of confidence in the citizens that the government will provide necessary services.
Director
So
Dietz, will you put the mic
That was
up?
the basis for the discipline, not the speech itself, which I think most people would say that speech was abhorrent. But we're not here to talk about whether that speech was abhorrent. We're here to talk about, does Metro have the right to regulate speech of employees who identify themselves as Metro employees, and then speak on things in a controversial manner? The government cannot regulate speech unless the government has an interest in internal discipline and control, and the ability to provide services and have the constituents have confidence in those services. So I just want to make it clear what the issue is tonight, because that's a fine line, but that's where we are.
Thank you, Director Dietz. Councilmember Sora, and then Councilmember Evan Siegel, and then Vice Chair Toombs.
Thank you, Director, for doing the lawyer part. Being a non-lawyer, I want to make it come full circle so you understand what I'm saying. The way the people feel impacts that confidence, right? And so it's the speech that led to the people not feeling the way that they feel about the government. Or if we act any other way, it also affects how the people feel about us. So we handle this in terms of, and I know the chief has been covered, that's why I did not want to talk about what happened internally in terms of the disciplinary action. But I wanted to speak that in addition to that, if this should go and we should cower, then we're sending a message to the people that can impact the people's confidence in the government. So thank you.
Thank you. Councilmember Evan Siegel, you're recognized.
I just want to clarify that I heard something right. This was a temporary demotion, and this person is back in the original role as of today. Is that correct? Or just
Director Dietz, can you answer that on the mic for the purpose of the viewing audience?
Again, thank you, Madam
Thank
Chair.
you.
That's correct. He was reinstated. He did lose some pay, and he has a claim for back pay of $8,000, I believe.
I think my only comment would be that sounds like an incredibly light punishment for somebody who is suggesting that they do not care about large swaths of the people that they are sworn to protect. So I would also want to not settle this at this time and enrich him further.
Again, that's exactly why we defended. We were involved on the front end. We believed the discipline was both appropriate and lawful, and we defended it on that basis. So to some extent, we're in the choir with you. But we also have a duty to let the council know we have an opportunity to settle this case for 23% of what the council approved in the Josh Black settlement that we had a couple of years ago with again, another employee in the fire department. That settlement cost us $450,000. So when we get a chance to settle this case for 105, again, we're not going to prevent you from having that option. If you turn this down, we will gladly litigate this case further.
Thank you, Director Dietz. Councilmember, do you have any other questions? Okay, Vice Chair Toombs, you are recognized. And then Councilmember Webb, you'll be after Vice Chair Toombs.
Thank you, Madam Chair. I'm also going to be voting against the settlement. I completely understand the legal argument and the rationale for putting the settlement proposal before the council. My concern is going back to what Council Member Cortez said about the uncertainty for department heads, because yes, we can't regulate speech. However, we have that caveat if it causes a disruption. Well, what causes a disruption? And so I do have serious concern about, providing guidance for department heads for when they can step in when there is speech that crosses that line. So I won't be supporting the settlement. I understand the risk, but I agree with Councilwoman Sawyer and Councilwoman Kimbrough that sometimes we just have to take those risks.
Thank you, Vice Chair Toombs. Councilmember Webb, you're recognized.
I want to question the Joshua Lipscomb case that cost us $450,000. When we go to court for that, or when he goes to court, because we're going to be fighting against Turner, will he be able to reference that settlement? Because that's another firefighter that quit for 16 days, and then we settled with him for $450,000. Will he be able to reference that in the court lawsuit?
Director Dietz, you're recognized.
Thank you, Chair. Short answer is no. A settlement was entered into without any admission of liability on the part of the Metropolitan government. A settlement has no precedential value whatsoever. If he tries to introduce evidence of that, we will move to strike it from the record. It should not be a factor at all in this case.
Thank you, Director Dietz. Councilmember Webb, do you have another question? No, that's it. Okay, thank you. Councilmember Kimbrough, did you have another statement? You're recognized.
Yes, Chair. Did you want me? Okay.
You can sit.
Okay. I just wanted to say this, because I don't want us to mix and match here. I believe the statements by Joshua Black, I think that's his name, were aimed or referencing a body of the government. They were about the government. And that's kind of real free speech, in my opinion. What this captain was doing was geared and aimed toward a group of people, a protected class. He was referencing them. He was calling, at the height of this horrible murder, and he was referencing the Black Lives Matter and other, individual groups. Joshua Black did what I think people do and what you're entitled to do. He talked about a branch of the government. You guys are this, you're that. So I just don't want to mix those two up. It's not like he was saying something else, okay? All right, so I just wanted to state that.
Thank you, Councilmember Kimbrough. Councilmember Allen, you're recognized.
Thank you, Madam Chair. I apologize. This is a lot of lingual language for the non-legal of us to soak up. So I'm going to just ask you to repeat the answer that you gave me earlier, because I echo my colleagues' concern that we approve of just giving in and letting people get away with racial slurs. I'm as unhappy with that solution as anything. But I want to make sure that this whole thing at the Sixth Circuit doesn't then come back and finalize something that will subject us to this unless we go all the way to the Supreme Court. And if we're willing to do that, then let's do it. And I just want to make sure we're not setting ourselves up for some final place, or if that Sixth Circuit ruling, if y'all get to go to Washington and take it to the Supreme Court and we can settle this once and for all in the right way, then that sounds good to me too. But I want to understand all the options.
Thank you, Chair. The short answer is, if we lose at the Sixth Circuit, we will ask the Supreme Court of the United States to take the case. And there's some chance that they will. Ms. Bustle and I had a conversation yesterday about how I would sit in the back and eat popcorn while she argued this case in the Supreme Court of the United States. And, the truth is, this area of the law is evolving. I've already mentioned previously to this body that there's a big case in the Supreme Court that it's already been argued, the opinion will come out before June 30th about whether you as an elected official, have the right to block people on your personal or campaign social media account. You cannot block them on your government account or your government email, but can you block them on your campaign account? That's an open issue, and we'll get a ruling on that. This whole issue about social media is evolving, and it's a relatively new phenomenon in the body of law. First Amendment law goes back to the very beginning of the country. But in this sphere, you're going to get opinions that come out one way or the other. Unfortunately, those of us who are involved in litigation know that one of the risks you take is when you go up to the Court of Appeals at the Sixth Circuit level, we may get an adverse ruling with guidance that we do not like. We may win, and we'll celebrate that. I guarantee you we'll celebrate. But if we lose, we don't have control over what guidance they establish in their language ruling against us. And that guidance is binding on the lower courts and us. So if we go up to the Sixth Circuit, the range of outcomes is from wonderful, great, we win, wasn't it great that we appealed, to we lose, and in the result, we get an opinion that diminishes what we believe our rights are to impose discipline in these cases. We could ask the Supreme Court to take the case, and it's the like an eye of a needle to get a case into the Supreme Court of the United States. It's so rare. The numbers are significantly against us, but we do believe in good faith this could be the kind of case they might want to take. And we would, if we lose at Cincinnati, we will file a petition for writ of certiorari with the U.S. Supreme Court, for sure.
Thank you, Director Dees. Thank you, Councilmember Allen. Councilmember Gamble, you're recognized.
Thank you, Chair. Just a question for Mr. Dietz. You mentioned that the individual was reinstated to the fire department in a demoted position, but he currently works there. Was that a part of the settlement, or was that a part of the judgment?
Thank you again. Council member, that was a function of time. It had nothing to do with the settlement. The discipline was imposed for a period of 6 months. That 6 months expired, and so he was restored to the rank of captain. It had nothing to do with the litigation per se.
Thank you, Councilmember Gamble. Do we have any other questions? Councilmember Cap, and while he's making his way to his desk, Director Dees, I have a question. With Mr. Turner being reinstated to his position, do we know if he undergone any type of training, any type of racial bias training? Is there any, I guess you could never have 100% certainty, but is there any certainty for the residents of Davidson County that this gentleman has maybe learned something a little differently so that he does not continue in this behavior? What assurances do we have that this won't continue?
Well, I would say passage of time is one assurance. He has certainly not had any work-related issues since this happened, and this was in 2020. So there is no indication that he is unable to do his job. He's performing his job duties well, from what I have heard. He was counseled before he was demoted. He was counseled for some social media activity, and so when he was actually disciplined, that was kind of the second incident that came to their attention. I don't believe, I don't honestly recall whether he went to any sort of, sensitivity training or anything. I think at this point, with the adverse ruling at the trial court, that would be a little tricky for us to suggest that the fire department do, because the court has effectively said he had the First Amendment right to do what he did. But I can report to the council that he has had no adverse employment-related issues since this discipline occurred.
Thank you. Councilmember Cap, you're recognized.
Thank you, Chair, and thank you for recognizing me, even though I'm not a member of the committee. I want to say that I really appreciate y'all's willingness to litigate. For those who aren't trial lawyers, it's not always that you find a lawyer who's willing to litigate. And one thing I really appreciate about y'all is your willingness to do that. I also really appreciate what my colleagues have said here today. And as a former trial lawyer myself, I find that, often there are times when even when the forum seems adverse, sometimes you got to stand up and argue what you believe. And I incline to think that this may be one of those cases. And so I'm inclined that way in this instance, but I want to, I think, draw out a couple of clarifications from y'all, if I may. The first is that this proposed settlement would be done without any admission of wrongdoing by Metro. Is that right?
Director Deets, you're recognized.
Thank you, Chair. Absolutely. And that's true for every settlement we bring to this body. There is no admission of liability.
Thank you. And adverse ruling at trial would necessarily involve a finding, were it to go against us, that we had engaged in wrongdoing.
Well, the finding would be that we had violated Captain Turner's First Amendment rights. And that would be a case that would be looked at by other judges in the Middle District of Tennessee, but it would not have a precedential effect on other courts in Tennessee and sometimes even among our trial court judges. They may say, well, we recognize what Judge Richardson did in that case, but in this case, when we weigh the balancing test, we come out on the side of the government. So I'm not worried about losing this case at trial and that being a negative binding effect on us or other courts. These cases are so fact dependent and they are subjective. So I'm not worried about that. But the problem does come, again, if we get a terrible ruling out of the Sixth Circuit.
Yes, thank you. And that's my next question. Is it your advice to us as the clients in this situation that you're advising us that we're likely to receive an adverse ruling at the Sixth Circuit?
I think absolutely not. I think it's, excuse my language, I think it's a crapshoot.
I'm not sensitive. Thank you.
My paralegal who is watching from his home texted me a moment ago to say that the reversal rate at the Sixth Circuit is 13.4%. So we have defied those odds before, but it is a tough road to hoe.
Sure. And I really appreciate that clarification, and I appreciate y'all's willingness to litigate. I think this is an instance where I don't believe that we violated this person's rights, and I think this is something that we need to litigate to the mat. And I appreciate y'all's willingness to do that and to also come here and recommend this settlement to us so that we can.
Thank you. We appreciate all these comments tonight.
Thank you, Director Dees. Thank you, Councilmember Cap. Any additional questions or comments? Councilmember Cortez, we're going to let this be the last one. You are recognized.
I just want to say thank you to the paralegal watching at home in such detail. I do actually, it was a fantastic piece of information, so thank you.
Thank you, Councilmember Cortez. Seeing no additional hands for discussion, all those in favor of approving the settlement, please say aye. All those opposing the settlement, please say nay. Is there anyone that is abstaining? One abstention. Anyone else abstaining? All right, we have 0 in favor, 11 against, and 1 abstention. All right, RS 2024-286, Porterfield, Evans, Welsh, and others approves the application for the Justice for Families Program Grant for the United States Department of Justice to the Metro Office of Family Safety to focus on finding and implementing collaborative multi-agency solutions to increase interpersonal violence, victim safety, and offender accountability. Can I get a motion? Is there a second? It has been moved and properly seconded. Is there any discussion? Seeing none, all those in favor say aye. Any opposed, nay. Anyone not voting? Motion carries 13 in favor, 0 against, 0 not voting. RS 2024-287 Porterfield authorizes the department allowed to compromise and settle the claim of John Doe against the Metropolitan government in the amount of $145,000 to be paid from the Judgment and Losses Fund. Can I get a motion? Is there a second? It has been moved and properly seconded. Is there any discussion? Councilmember Kimbrough and then Councilmember Cortez.
was this settlement? What's this settlement about?
Director Dietz or someone from legal, can you all speak to this particular settlement? It's RS 2024-287 to settle the claim against John Doe. Thank you. You are recognized.
The settlement amount is $145,000.
What was the settlement about was the question.
I apologize. It was about, there was an individual who is HIV positive who had applied to the police department because of a charter provision that adopted the U.S. Army standards. And at that time, the U.S. Army standards prohibited anybody with HIV from serving. So Metro had just adopted those standards. Because of that, he wasn't allowed to be a police officer. He didn't pass the civil service medical exam. And he had filed a lawsuit under the ADA asserting that that provision and the withdrawal of his offer discriminated against him on the basis of his disability.
Thank you. Councilmember Cortez and then Councilmember Sorora.
And with this case, this was not taken to summary judgment, so we don't know what the court where they're at on this.
This is an early settlement, but there are cases out of the Fourth Circuit that were specifically looking at the Army standards. So that appellate court level that had found that they did discriminate, that those standards discriminated against people.
So it looks like this would not go in our favor if this went beyond this.
Correct.
Okay, and do we know what the financial liability would be if it did go forward?
This individual is represented by kind of a plethora of lawyers, Lambda Legal, several major law firms in New York and Chicago, and their attorney's fees are already over $300,000. So if he was successful, those fees would only go up as we litigated. So I would imagine the judgment would be at least $300,000.
So are we on the hook for the legal fees in addition to the settlement?
No, the settlement is inclusive of legal fees, but if we went forward and litigated, we would be on the hook for the fees that they claimed.
Okay, thank you very much.
Thank you, Councilmember Cortez. Councilmember Soror, you recognized?
Thank you, Chair. Now being an attorney and reading through the financial analysis, I thought somewhere when I was reading this, it did say that the individual did not disclose their situation. And they also are aware that Metro does not recruit people following the Army standards. That's what I read. So if they know about it, and if that was our policy at the time of the employment, why is that? Again, not being a lawyer, I'm just talking about just reading what I'm reading. The question that comes to mind is, then why are we liable? I mean, what is the point?
So he did not disclose that. There are situations where a blood test will reveal a medical condition that somebody did not know that they had. But him not disclosing it did not disqualify him from employment. When the blood test came back that he was HIV positive, it started a dialogue, and then those standards kicked in. At which point, because he did not meet those standards, his offer was revoked.
Councilmember Soror, did you have any additional questions? Thank you. Councilmember Allen, you're recognized.
Thank you, Madam Chair. I just want to make sure we get on the record for the viewing audience that we have since changed our standards, and so that this will not happen again.
Correct, and we've worked with the Civil Service Medical Examiner. That is not our practice now at all.
Thank you so very much. Do we have any additional questions? Seeing none, all those in favor say aye. All those opposed, nay. Anyone not voting or abstaining? Motion carries 12 in favor, 0 against, 0 not voting. We're almost done, y'all. Bills on second reading, Bill 2024-230, Porterfield Evans amends Metropolitan Code Section 12.72.020 with respect to the establishment of administration fees charged at the Metropolitan Government's toe-in lot. Can I get a motion? Is there a second? It has been moved and properly seconded. We do have an amendment. Can I get a motion on the amendment? It has been moved and properly seconded. I will explain the amendment and then we will open it up for any discussion. The amendment simply states that in addition to the chief of police establishing the rates and the administration fees related to the operation of towing lots, it's also approved by the finance director. So this is just giving our finance team and our finance director the opportunity to look at this prior to approval. So with that being said, is there any discussion? Councilmember Kimbrough, you're recognized.
I'm sorry, I have a question. With the tow-in lot, I know I should have read this, but are they saying they're increasing fees?
Do we, Director Darby or Deputy Chief Gilder? Welcome. We haven't heard from you today, Deputy Chief. Come on up. You are recognized.
Thank you. I almost made it. No, ma'am. So apparently there was an administrative fee that was in the code for a number of years. At some point, there was an amendment made to that portion of the code not related to that fee, and that fee inadvertently, as far as the research from Metro Legal has determined, got taken out of the code. So we need to get the fee re-implemented. The recommendation was that this type of fee, what we would normally do now, rather than setting a particular number in the code and that staying in the code in perpetuity, is to allow the department. Most departments have their director has the ability to set the fee according to cost, and so that's what this legislation would do, is allow the chief to set it according to cost with the amendment upon consultation of Finance Department.
Thank you, Deputy Chief Gilder. Councilmember Kimbrough, you have a comment?
I have a question.
Okay.
Okay. I'm asking you this because I know people who have had, like, the tow-in lot, you take cars sometimes for evidence. Is that correct?
Correct.
Okay. And maybe at the end of the investigation or whatever, they want to come get their car back. There's a fee for them to get their car, right?
There are fees related to the cost of towing, and there are fees related to storage. So it depends upon how the car ended up down there and how long the car remained down there as to what that fee would be.
Right. And when you take someone's car and tow it in for evidence or whatever, you're going to do it. They don't get a say. They can't say, no, I decided you can't take it in and dust it or print it or whatever. If you want to take their car, you take their car, right?
Well, but within the confines of the Fourth Amendment. So, I mean, if I'm taking their car, it's because I have a legal basis, probable cause,
Right.
probably a search warrant. In the case, if I'm going to take their car from them, there's probably a search warrant involved where a judge has authorized me to take that car.
Correct. But then to get it out, which the judge has nothing to do with, to get it out, they owe fees to get it out.
Correct.
Okay. And so you're saying now on top of those fees, there could be an administrative cost that the chief of police decides what it would be?
This is the fee that's been in place at least probably for 2 decades, I would say. I haven't gone back to research if it goes beyond that. So this isn't a new fee. This is simply fixing a code error where this fee had been in there, had been charged, and then was inadvertently removed. So it would not actually change the fee.
I thought you said the chief of police will decide the fee.
So the fee was before set by the code. It was a specific number that was in the Metro Code.
It was taken out.
And the recommendation from Metro Legal was that other departments in these types of scenarios, rather than putting a particular number in the code that remains there until a council, comes back and has to have an ordinance to amend the code, if it allows the department head to set that fee based upon the cost that that department is incurring in relation to whatever service it's providing. And so that's the way this is drafted. It would allow the chief to set it based upon what those costs are. If those costs go up in 10 years, then the chief can do that, again, in consultation with finance.
So the chief sets the fee.
Yes, ma'am, in consultation with finance.
And is there any particular formula for that, or?
I couldn't speak to the exact formula that is used. Again, it has to be based upon, in relation to the cost that the department incurs in relation to providing that service.
So, for example, let's say the fee is 100. He's saying that our cost is 100. It needs to be 100 right now. Does that go into the code, or does the code allow him to change it as necessary on his own without it being in the code?
My understanding is it would not be in the code.
Right.
The code empowers the chief to set the fee, but
Right.
you may want clarification on how that. Again, this is based upon how other departments do it. So I mean, I can't speak to that. I haven't seen those, but I believe like TLC, for instance, does something similar when they set rates.
Thank you. And I just want to say this, and maybe we need to visit it at some time, because I have dealt with people who have had their cars towed for whatever reason by the police. And I'm not talking about the typical, it was on the side of the road, or they say, we want to print this, or we want to take a look at this. And sometimes it may stay for months. I always thought this was very unfair, but it may be at the tow-in lot for months. And then when you go to get it, even though you had nothing, it could have been your mother's car, or who, you know, somebody has nothing to do with anything, then sometimes they find out a car is not even related to an incident, a criminal incident at all, but to get it out. And I just think that is so wrong. And to me, it seems illegal. But to get it out, you have to pay all these fees, even though there was nothing you could do to get it out early or to go pick up your car. You have to wait. You do not have a choice because you have had something signed by some judge, or there's some policy or something, and your car is over there. So you have these fees. And then on top of that, and it may have been a good thing it accidentally got kicked out, but then on top of that, they're saying there's some administration fee you're going to have to pay too because we kept your car for you against your will. I just always thought that was kind of stupid. And I think at some point we need to address that. And I understand what they're saying, it inadvertently got kicked out of the code. But I'm going to say I know on that just because I know more about that. And I just know it doesn't make sense that you can hold people's car, take people's car. And I can't think of everything right now. I think there's some other incidents that may not be criminal related, that your car ends up in the tow-in lot. And sometimes people don't even know where their car is that's been towed. And you're accumulating these daily fees, and then to tack on an administration fee on top of that. I just think that some of the fees to begin with are wrong, especially when you cannot request that it be released. You have no control over your car being there or the length of time it will be there. I just think that's fundamentally wrong. And maybe at some point we can address it. Thank you.
Thank you, Councilmember Kimbrough. Councilmember Toombs, you're recognized.
Just to clarify, Chair, the purpose of having the finance director also look at this is to have that balance so that the cost, the fee reflects the cost to operate or provide the services at the tow-in lot, right?
Would someone from finance like to address that? Ms. Wiggins, you're recognized.
Thank you, Chair. Yes, you're exactly right, to make sure that the costs are appropriate, not too high, and also that they cover the actual costs. So just to get a set of eyes to make sure that it's completely balanced.
Okay, thank you.
Thank you, Councilmember Toombs. Thank you, Councilmember Kimbrough, for your questions. This sparked a question from me. Director Darby, is this amendable on third reading? Okay, the answer to that was no. This makes me curious about if there is any mechanism that if someone's car was, I guess, impounded and it was found that maybe the person was not guilty of anything, is there a way that that person can be made whole? And I don't know who that question, I don't know if that's a question for legal or Director Darby or who may be able to answer that question.
It would probably be up to the
the court at some point to make a determination as to whether fees would be appropriate. But here we're talking about, we're talking about the cost for storage and the actual cost for keeping the car there, and it pays for the staff to manage the lot and that sort of thing. So I think that it might be, I don't know if a court would be able to tell Metro, you can't charge your cost for the service that was provided. But perhaps Wally has a different approach. Mr. Dietz, sorry.
Fair. Let me ask a follow-up question for that, Director Dees. So my follow-up question would be, then if that happened to an individual, if my car got taken in and I didn't do anything wrong and it was held for many days, I had to pay this fee. If then it was released and you saw that the police or whomever said I didn't do anything wrong, could I then go to court to try to get those fees back from someone, is the question.
I think in that case, there might be some discretion, but I would, I think Deputy Chief Gilder may have some thoughts about that. In your scenario where your car was towed wrongfully, there may be some remedies for you in that instance, but Chief Gilder can speak to this.
I will say that I can't think of the particular incident at hand, but I do know there has been an instance where if we felt like there was an issue where maybe a car was towed improperly, then I know we have refunded fees before, released a car without fee. So that has happened. I would also say that, if it is a situation where we think the car was towed properly, but the person believes that they still, for whatever reason, that the fee was improper, that they were deprived of their property, then we'd probably direct them to, submit a claim with the Department of Law and go through that process.
Okay. Thank you, Chief Gilder. Councilmember Kimbrough.
Chair, I'd just like to say this. You shouldn't have to go through those measures. You shouldn't have to. Most people, if they have the money, are just so relieved that now I can finally get my car back that they pay it. They don't even question it. What they're saying, they're not speaking, you hear them say may, could, should, probably. There's no absolute language here because they do charge you. And you would have, sometimes if you know somebody that knows somebody, maybe you can get it back. But I know I have had to fight, and you shouldn't even have to go through that for someone who's had their car towed that should have never been towed in the beginning. You have to have a lawyer that's willing to advocate for you, to go to court for you. You're talking about if you're waiting on a judge, that means you're in a courtroom. That means you had to do something and get to a courtroom. You should not have to do that. You should not have to do that. And then you're talking about, well, we want to pay the staff and we want to do this and we want to do that for something that was wrong to begin with. When you take someone's car and they've done nothing wrong, there should be something that says something to the effect, if this case was dismissed, if this was in error, your car looked like that car, we accidentally took your, there should be something where you don't have to go to court, where you don't have to try to figure it out. But most people are just so relieved, they just, you say it's how much, let me pay it. If it's the people that don't have the money that really get the raw end of the stick. Well, really, even if you do have the money, you're getting a raw deal because you shouldn't have to do it. But I'm telling you, as someone who has had to fight at least twice, I believe, for someone to get their car back, it's wrong. It's just wrong that your car is taken. You may have done nothing wrong, but say you did do something wrong and your car is taken, and at some point they give it back. It was still taken involuntarily. You know what I'm saying? It was still taken. Maybe they said they smell marijuana and we're taking your car, we're going to tow it or whatever. It's wrong that they can keep it. Well, we haven't gotten to it. We haven't processed it yet, but we'll get to it as soon as we can. And your car's been there all those weeks. Then you have to pay for the storage for every day, plus some fees and whatever else. I'm saying that is wrong. And now we're saying, hey, we accidentally left something out of the code, we need to put back in the code, so the chief can add an administrative fee on there as well, based on our cost or whatever, something that's fair. We don't know what that figure is, and it may change over time, but we're running by Metro Legal, or finance. It's not right. That's not fair. That's not fair. It is wrong. And I think at some point we as a body should address that. It's just not right.
Thank you, Councilmember Kimbrough. And my apologies, y'all. We are not on the amendment. So what we're going to do is, Director Deets, is it on the amendment? Let's cap this for the, let's bring the conversation back to the amendment, y'all. The amendment is only saying, are we going to allow the, as approved by the finance director? And then once we approve or vote down the amendment, then we can continue that discussion. Is there any additional discussion on the amendment? All right, seeing none, all those in favor of the amendment, say aye. Any opposed, nay. Anyone not voting? All right, so the amendment passes, 12 in favor, 1 against, and 0 not voting. Director Dietz, I'm gonna give you the opportunity, and then Councilmember Toombs.
I'd like to say, and Councilmember Kimbrough, I understand exactly your concerns. I have 3 really brief comments. First of all, I hope cases along the lines of this hypothetical will be very few and far between. So hopefully there will not be a large number of these instances. Secondarily, it'd be, in my experience here for 3 years, I've learned that there are lots of lawyers who are very glad to pursue claims against Metro, not pro bono, but on a contingency fee case where the client does not have to pay in advance an attorney's fee. The third thing I have to say is we have a substantial claims department that they're not that visible to the council or to anybody else, but our claims department processes claims every day. The leadership team in Metro Legal meets twice a month to approve settlements. Some of those are under $5,000, and you never know about them because they don't need council approval. We settle claims all the time without making a claimant hire a lawyer. We're happy to deal with the person with or without a lawyer, and we settle claims routinely by citizens who are not represented by legal counsel. So I'm just saying that option is available.
Councilmember Toombs, you're recognized.
Chair, I just want to clarify, this administrative fee is the fee we've always charged, correct?
Director Darby, you're recognized.
I believe so, yes.
So we've always been charging it. It's just someone has noticed that it was inadvertently removed from the code, correct?
That's my understanding, correct.
So this legislation is just about adding the fee back in to continue to cover the cost of maintaining the tow-in lot and the services that are done in that lot.
It adds the fee back in with the ability of the chief of police to set the rate of the fee with the approval of the finance department, or the finance director, which would ensure that that rate is set at a cost,
Is actually
cost
covering the
recapture.
cost, correct? Okay. So I hear the concerns about it being unfair. If you've ever been told, it's always unfair to have to pay those costs, which can, on the private side, can be extremely high. However, I think that's a separate matter, and it sounds like some research needs to be done. Maybe there's some possible legislation there, but again, it's separate from this legislation that we're considering this evening, which is just correcting the code to allow Metro to charge to cover the cost of maintaining the tow-in lot. That's all I have, Chair.
Thank you, Councilmember Toombs. Councilmember Kimbrough, you are recognized.
I just want to ask this. I heard what Council Lady Toombs said. This particular item is something that's tacked on to other costs. Is that right? The administrative fee. You still have your, I guess, docking fee or whatever. You still have other fees that exist. Is that correct?
Director Darby?
This is the cost of, I believe, the cost for storage at the tow-in lot. So if there were wrecker fees, that would be something that is separate from the storage cost to store your car at the tow-in lot.
Who would know definitively?
I don't know if Deputy Chief Gilder knows what other costs are attendant to the tow-in lot fee.
Deputy Chief Gilder, you're recognized.
Thank you. I don't have a breakdown of the cost, but yes, it's my understanding that the towing cost is a separate cost. If your car were towed, not all cars go to our towing lot. They're primarily the ones that are involved in a crime and they're either being held for evidence purposes, because if they're not, if it's just like a car crash, they don't come to our towing lot. They go to a private record lot where you're going to be charged a towing fee and storage costs, very similar to like what we're talking about here, but just charged by a private entity.
Right, but may I ask him a question?
You're
But
recognized.
my question is this, aren't there other costs already prior to, because for some time you've been operating without this administrative cost because it was inadvertently left out, is that right? That's why we're here, isn't that why we're here?
Chief Gilder.
My understanding is that one of our employees discovered it missing from the code and then contacted Metro Legal to find out where it was in the code. And so they're just trying to get it back in the code. So no, I don't think there was ever a period where this wasn't being administered.
So you were charging it, it just wasn't in the code, is that right?
Nobody noticed it wasn't in the code, correct?
Right, but you've been charging it and it wasn't in the code, is that right?
Until we noticed it wasn't in the code.
Right, so you've been charging it and it wasn't in the code?
That's what yes. That's what I
Okay,
just said.
all right. Okay, and so now to correct it, I believe, Ms. Darby, what they're saying is we're going to not only correct it, we're going to give the chief more power to set the amount. Is that right?
Director Darby, you're recognized.
Yeah, much like other departments where the director would set certain fees, administrative fees, the chief would be given the authority to set the fee. The amendment that's going on would have the director of finance confirm that that fee is accurate. As a governmental entity, we don't have the ability to set fees in a way that is for the purposes of generating just revenues for whatever. Our fees have to be tied to the reasonable cost to provide whatever service it is that we're charging the fee for.
And one last question. This is it. It's for the director of Metro Legal. Sir, Mr. Director Dietz.
It's the
Director
question for
Dietz.
you, Director Dietz.
Okay, it's just this one last question. No, that's fine. You were talking about how you settle claims, do claims, and you don't even need that with an attorney. So now, how would John Doe citizen know that I've been aggrieved by the tow-in lot? I don't have the money. How would they figure out because I don't think the police say, hey, go to claims. How do they figure out to go to this claims department?
I defer to Deputy Chief Gilder on what the police would say or not. Good question. I tell you what, a lot of people find us. So.
Chief Gilder, you're
I
recognized.
can't begin to count the number of times I've referred people to the claims website because they've reached out, thought that they were aggrieved and owed money. And so I've directed them to the website to file their claim.
Thank you.
Thank you so very much.
Just
Yes, sir.
a point of clarification, not in respect to necessarily just fees. I'm talking all across the board where people, maybe there's a situation, property got damaged, they think we're at fault. I've referred them, no matter what it's for, I would refer them to the claims division.
Now, are you over there at the tow-in lot?
No, ma'am.
Okay, all right.
But things often find their way to me.
Thank you.
Thank you. Councilmember Kimbrough, and just for the sake of the committee so that we can just kind of all be on the same page here, I did just confer with Director Darby, and I am going to request to meet with MNPD, Legal, and Finance to discuss if there are some changes that we could possibly make to this particular policy, so that we could just discuss like the process for people to go through to get a refund, making sure that that's transparent. Also to have a conversation about the amount of time it takes to process vehicles, and just trying to see if we could work together to come up with something which will be separate from this. It will be a separate piece of legislation if legislation comes out of it. But I did just speak to Director Darby about that during this conversation. So, Councilmember Kimbrough, if you have any additional concerns, if you don't mind directing them to Director Darby in email, and she can also bring those to the conversation when we meet.
Thank you, Madam Chair.
You are so welcome. Do we have any additional questions or comments, y'all? Seeing none, all those in favor say aye. Any opposed, nay? Anybody not?
Wait a minute, hold on. I thought you were saying to adjourn.
No, ma'am, we still.
What are you talking about now?
We're about to vote on this piece of legislation as amended.
I thought we voted.
We voted on the amendment, so now we're about to vote on the legislation as amended. So all those in favor say aye. Any opposing, nay? Anyone not voting? All right, so it passes 10 in favor, 1 against, and 0 not voting. We are on our last piece of legislation, y'all, and then it is a very brief announcement. BL 2024-231, Porterfield, Evans, Walsh, and others approves an agreement between the Metro Nashville Fire Department, Emergency Medical Services Division, and Vanderbilt University Medical Center to provide clinical training for the students enrolled in the Emergency Medical Technician Program. Can I get a motion? Is there a second? It's been moved and properly seconded. Is there any discussion? Seeing none, all those in favor say aye. Any opposed, nay? Anybody not voting? Motion carries 11 in favor, 0 against, and 0 not voting. So we have 3 very brief announcements. The first announcement is happy birthday to Vice Mayor Henderson. A little birdie told me that today is Vice Mayor's birthday, and there are cookies in the kitchen available. If anybody wants some, they'll be there today and tomorrow. The second announcement is we did discuss previously some working groups for our Budget and Finance Committee. I did want to announce what those working groups are very briefly, and then if you're interested in working in one of those working groups, I'll give you the opportunity to display that by raising your hand. The first group is going to be a human resources work group that will study the vacancies throughout Metro to identify staffing patterns and efficiencies that may contribute to savings that are best utilized for alternative budget needs. And this group will be led by Councilmember Toombs. The nonprofit funding process work group seeks to clarify and streamline the budget process for nonprofits to receive Metro funding, aligning the direct appropriations and community partnership fund request process in a transparent and equitable application and selection process. This will rely on department expertise to evaluate what Metro functions can be augmented or better performed by nonprofits. This group will be led by Councilmember Allen. And then the procurement process work group will review the procurement process to identify ways that processes can be improved and to ensure the charter requirements meet the current needs of Metro government. This group will be led by Councilmember Sorora. So just so that everyone will kind of have an idea of how the groups will work. Each council member that was just named will be the person that will be chairing that particular work group or leading that particular work group. These groups are all voluntary, so please don't feel any pressure to join a group. But if there's a particular expertise that you have or interest in one of these groups, please feel free to lend your expertise. The idea is that these are small working groups. The person that is leading the group will work directly with the council office to schedule when the groups will meet. For the human resources group and the nonprofit group, we're looking at hopefully accomplishing short-term and long-term goals. The short-term goals will be addressing the budget process coming up this May, June, so this upcoming budget, and then long-term, how we will look at these those particular issues for the duration of this term. And for those two particular issues for our newer council members, these are issues that kind of come up every year throughout the budget process. There have been different ways that nonprofits have requested funding, whether that's going through the mayor's office or getting added in by a council member during some type of like budget amendment process. The process hasn't been very clear to nonprofits, and we want to make sure that the process is equitable so that everyone understands how they can best advocate to get their needs met. And then the same thing with the HR work group. Looking at vacancies has been something that we've been doing for the last few years, and we just want to make sure that we are right fit in our departments. With regards to that procurement work group, that work will start a little bit later, so that may start after the budget season, or at least not within the first few months. We did just get a new person in procurement, so we want to give Councilmember Soror the opportunity to reach out. She had previously been working with Michelle Lane in procurement, but now that we have a new person, we want to give Councilmember Soror the opportunity to reach out to that new person and work with them directly before, let them get a little settled in their position before we start trying to change things or making recommendations to possibly improve that process. So with that being said, if you are interested in working on the human resources work group, so that's staffing patterns and right fit in department sizes and looking at vacancies, could you please raise your hand? And I see Councilmember Quinn Evans Siegel. And Councilmember Johnston may be interested in that group just based on past conversations. But Councilmember Toombs, you got Evan Siegel that's working with you. And I'll be serving as ex officio on all of those committees. For the nonprofit funding process work group, looking at how nonprofits are funded through our budget, led by Councilmember Allen. If we have anyone that's interested in work on that work group, please raise your hand. Councilmember Spain and Greg. All right, thank you so very much. And then the procurement process work group with Councilwoman Soror. If you're interested, please raise your hand. Councilmember Evans, Councilmember Gamble, Councilmember Evans Siegel. So Evans and Evans Siegel and Gamble. All right. That is everyone. Thank you all so much. Again, you will get information from, you'll get some more information from our the council office this week outlining that process. And then the last thing is we wanted to address the education committee. I know we had talked about this briefly before, but with the consolidation of some of our committees, we did want to make sure that we are still uplifting and acknowledging that education is a big priority to our Metro Council. And with that, I will be working with our school board members as they are going into budget season to make sure that we are able to work together and allocate an appropriate funding for MMPS and making sure that the needs of our school system are being addressed. So I will be working as a liaison with our school board to make sure that they have that assistance going through the budget process. And with that, if there's nothing else, meeting is adjourned. Thank you for hanging out and enjoy your cookies.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.